Welcome back, everybody. My name is Guy Neighbors. Welcome to Foreclosure Defense Paralegal Service. We are different and we prove it. Today, we're going to talk about the two biggest mistakes is believing the attorneys. The attorneys make people believe that the lender is actually foreclosing on your property. And from what we found, that's just not the case. People have to check the signatures on your foreclosing documents that they served against your. What's going on now is the lenders are cashing in on the mortgage insurance, okay? And when they do that, it usually shows on your credit report as a charge-off. And not only do they cash in on the mortgage insurance, they also claim the loss on their tax at the end of the year. And this is very important to understand, because once those things happen, okay, then these attorneys bid on these alleged debts. And it's pretty obvious, okay? It shows as a charge-off on your credit report, so clearly the bank is not the one that's actually foreclosing on you. Attorneys buy these debts and try to collect on them, just like a credit card debt or medical bill or any of those debts. They're the same thing. As a matter of fact, when you get emails from these attorneys that are harassing you and foreclosing on your property, down at the bottom of the email, it usually says right on there that this is an attempt to collect the debt, and any information received will be used to collect on the debt. So I think that's the number one problem that people make in foreclosure defense. They don't go after the right person on their lawsuit, and they believe that the bank is actually foreclosing on them. And they also believe that the bank's going to help them. And the bank's not going to help you, because the bank's already cashed in on the mortgage insurance, and they're not interested in helping you. We have people in our Facebook group that are running into this problem, and they found out after calling the bank a whole bunch of times, the bank actually tells them, you need to call the attorneys. So that's the number one tip. You need to check your paperwork and see who actually initiated the foreclosure against your property, and the signature on that paperwork is what should be the number one defendant on your wrongful foreclosure lawsuit. Now, in a non-judicial situation, the paperwork that you need to check would be your notice of default letter or the notice of cure letter, whatever letter they send you saying you're behind and they want their money, and this large amount is what you have to pay, which includes the attorney fees and everything. That is the letter for non-judicial foreclosure that actually initiates the foreclosure. That notice of default letter is used to activate the notice of sale clause in the deed of trust. The whole thing is pretty sketchy how they do that, but that's the way it works so far. And so we have to be aware of that. Okay. The second biggest mistake that homeowners make when they're fighting foreclosure is they trust the attorney to help you. I have so many people that call me who trusted their attorney to help them, and the attorney totally threw them under the bus. People don't realize that the attorneys are making money off of this situation, and they're number one, they're not going to help you get after the bank. Okay, I'm sorry, it's not going to happen. I have not seen it happen. Okay, attorneys are not going to help you get after the bank. They're not going to help you get any evidence on the record that you can use in your favor in an appeal. Okay, and really, that's one of the most important goals here in this foreclosure defense. The first most important goal is to set yourself up to block the eviction process. The second goal is to get evidence on the record that you can use that appeal. These people will tell you in court, go ahead and appeal it. It's denied, go ahead and appeal it. Well, they have no problem saying that, because they know that you don't have nothing on the record that you can use for an appeal. Because when you do an appeal, okay, everything is done from what is on the court record already. You can't add any evidence into it. So you have to get your evidence on the record before the court tries to throw you out, so that when it's time for your appeal, you have the evidence on the record that you need. Okay, so let's get back to this. The second mistake is trusting the attorneys. Most of the attorneys offer three options for foreclosure defense. Loan modification, short sale, and bankruptcy, okay? Those three, very few people end up in their house after those three, okay? The loan modification, if you're facing a non-judicial foreclosure, The loan modification is ridiculous because you don't have time for that. Okay, in a non-judicial foreclosure, they send you that notice of default letter and they tell you, if you don't cure this in 30 to 45 days, we're going to sell your house. Now, the law says that if you're involved in a loan modification, they can't foreclose, that everything has to be put on hold. And it's called dual tracking when they don't put it on hold and they foreclose anyway. But they do all day long because there's nobody challenging them, taking them to court or suing them for their unlawful behavior. Okay, so you don't have time in a non-judicial foreclosure to do a loan modification, to call all these people. You don't have time for that. Because when your time is up, when that 30 to 45 days is up, they sell your house. And sometimes they sell it before that time is up because they're so used to just stepping on everybody's face. They get away with everything. They're why wait any longer? They need to get that money in their account so they can move on to the next order of business and get the money from the next person when foreclosure that they do. So we need to understand that when you're facing a non-judicial foreclosure, you don't have time to mess around. You don't have time for a loan modification. You don't have time to mess around with an attorney because it's not going to help you, okay? You need to have your game plan activated before you go to eviction court, okay? If you don't have your game plan in place before you go to eviction court to block the eviction court's process, you're going to be in trouble, okay? Because once you get in eviction court, you got 5 to 10 days to get off the property. And if you don't get off the property, they send the police out to help you with that. So you got to have your plan in place. What we suggest to help you in eviction court is to make sure that you have a title dispute on the record before you go to eviction court. And you can watch some of my other videos. It talks about that a little bit more in depth. But you have to have that title dispute on the record because eviction court can only hear immediate possession. And most of us don't know about this. So we go to eviction court arguing a title dispute, and the judge ain't trying to hear it. We can't rule on title dispute, or we don't want to hear that, or whatever. They won't tell you they don't have jurisdiction to hear it, and they won't send the case over to the right court that has jurisdiction to hear a title dispute. Okay, you have to figure out how to get your case out of there, and that's what our documents help you with. We have documents that can help you challenge a jurisdiction of eviction court. You attach a file stamp copy of your lawsuit in federal court, which is your title dispute. And we also have a removal document to actually remove the case from immediate possession court over to federal court where your lawsuit is filed. Okay, that's if you don't have that in place, that's the only way we figured out to block the eviction process, to give you a chance to fight for your property while you're still in your house. Okay. The foreclosure defense strategy should block the eviction process. Okay. Blocking the eviction process and staying in your home should be the #1 goal. Okay, the second goal should be to get the information on the court record that you need to support an appeal. And if you have to appeal, now you have stuff on the record to appeal that the judge doesn't want to sign his name or her name onto because they're not trying to go on the record showing all the things that the bank is doing wrong. Okay, people need to understand you don't have to go into foreclosure court or eviction court and be the defendant, even if you are. Okay, you don't have to be the defendant, even if you are. We teach you how to go in and be the plaintiff, and not defend what they're saying you did, because that whole thing is fraud. You need to go into court addressing the stuff they did wrong at signing when they threw you under the bus. Because when they threw you under the bus in the beginning, what happened after the fact, the alleged mispayments, any of that stuff was irrelevant because you were violated at the beginning. And those are the things that we discuss in our deal. So remember, the two biggest mistakes that people make is believing that their attorney, the two biggest mistakes people make is believing that the foreclosure was initiated by the lender, okay? And the second biggest mistake is trusting the attorney without double checking or anything, or seeing or looking over their shoulders. Trust an attorney, period. I tell people, you can mess up your case yourself. You don't need to have an attorney mess it up for you. And I have not talked to one single person that hired an attorney to help them in a foreclosure situation, and they're happy with what the attorney did for them. Not one. And I've been doing this for a few years. not one person. And that's, that's actually shocking, but that's the way it is. And until we realize it, we're still going to be on the wrong end of that stick when it comes time to make these decisions and get the stuff done. So that's it for today. Our next video, we're going to go into a little bit more about the process that you guys need to be doing to cover yourself in the judicial foreclosure situation. And we're going to have a few updates about what's going on. Oh, also, we're going to talk about our new document. I have 2 new documents that we're rolling out, and I think people are going to really enjoy them. So that's what we're going to talk about in the next video. One of the documents is a motion to dismiss the foreclosure. I decided we need to have a few documents where we can use to try and stop the foreclosure while it's going on before we move it and do all these lawsuits and all that stuff. We need to start taking some shots at it right now, and that's what we're going to start doing with these 2 new documents. I think you guys are going to see they're very nice and they're coming very handy. So thank you guys. I'll see you guys on the next video, and please don't forget right down there, subscribe, click the button, click the bell so that you can get notifications, and share my site with people so everyone can see. Even if you're not facing foreclosure, it's good to learn this information because you never know when you might have a friend or a family member in this situation. So thank you guys. I will see you on the next video. Yo.